pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
My bitch a choosing lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes get the most, not the lesser. Trash like the fuck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm pulling business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side, if you know what I mean. I show you shit you never seen, the 7 wonders of the world. And I can make you the 8th if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker, walk a green mile. Piling up the paper on the dining room table, cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man, they need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get chose.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine partners.
Hello, everybody. It is Artie of Artie's Corporate Fiction. How you guys doing today? It's Wednesday, and I found another interesting. Well, it's a spicy video for you. This involves a protester appearing before Judge Simpson. This protester is, as you'll find out shortly, is a protester regarding the Israel. Palestine, the conflict going on in the Middle East, and you could probably guess on which side of the fence she's on. I'm curious as to see what happens. I saw in the comments that the lawyer ends up making his own personal statements on the conflict, which I'm not sure. I don't know if that's the best angle or really appropriate, but we'll see what happens here. We tried to copy TCAP. Yeah, Hitchbot, I saw that thing on Long Crime Network. That looks pretty wild to me. I have no idea what to say to that though. But I'm curious to see how this is going to go down. Ugh. All right.
Let's call the case of the People's State of Michigan versus Samantha Lewis.
Good afternoon, Your Honor. Benita Hoffman, Assistant Attorney General on behalf of the people.
Thank you. Good afternoon, Your Honor. Good afternoon to your staff. My name is Amir Macklett. I represent Ms. Samantha Lewis, who's president, standing to my right.
State your name, please.
Samantha Lewis.
Thank you. All right. This is an arraignment on 2 charges. One, resisting and obstructing and assaulting a police officer, and a charge of to carry along a trespass. Counsel, do you wish a formal reading of the complaint, or do you want?
Thank you. Respectfully, Judge, I'd ask the court to waive the formal reading of the complaint. Ms. Lewis understands the charges before her and will stand mute to both counts.
All right. Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. I will set this for a probable cause conference. And typically, as you know, our practice, we set the probable cause conference and then the exam comes along. So I won't be giving you an exam date. But I guess here's my question. I currently have the other matters that are set for exam February 12th, correct?
That's correct.
All right. So is this going to be something that is separate from those? Or
Yes, they're different days.
Yes.
It's a different protest. So different facts, different witnesses.
Oh, wait, so hold on. So wait, are these two charges involving one protest, or does she already have a case from a prior protest?
Different days. Okay.
It's still the same, essentially the same witnesses. It's the U of M police department. But yeah, they are separate facts and separate dates.
Separate
for
officers.
each
even.
charge? For each charge?
I don't think we'll
Yeah.
have an exam on the
Case.
12th for this particular case, not with as many co-defendants as we have on the other case. I think that exam will run for, quite a while, just because there's 5 or 6 co-defendants.
And, okay, here's what I'll do then. I'll set a probable cause conference for January 23rd, 2025 at 12:30. Timelines having been waived, then we'll figure out, after looking at everything, where this one will go from there. All right. Any issues regarding bond on this case?
Your Honor, with respect to bond, we are asking that you not have any contact with the University of Michigan's properties or any of the University of Michigan property or students except as necessary for medical care. We're asking that you refrain from any assaultive conduct. We're asking that you not have any contact with the Tahrir Coalition, which is an
With
organization.
I'm sorry.
Tahrir, TAHRIR.
What the hell is that? TAHIR. What? Sharia Justice Center. Is this what it is?
Coalition.
Sorry.
Tahrir, TAHRIR.
TAHRIR.
Coalition.
Coalition. What the hell is that? Oh dear God. Oh, it's a batshit insane pro-Palestine group. All right, that explains it.
Okay.
And that she not have any contact with Alice Elliott or
Hey,
excuse me,
Wazoo.
Alice Elliott or Josiah Walker.
Assuming a recommendation of PR bond.
Oh, yes, that's fine.
And it's Josiah, you said Walker?
Yes, Your Honor.
Counsel, any
Yes.
response to the condition request?
We don't object to personal recognizance bond, Judge. Ms. Lewis obviously has ties to the community and substantial support as evidence in the courtroom. I do have a strong objection to any prior restraint to this coalition or organizing or being a member or associated with the Tahrir Coalition. I don't know what the Tahrir Coalition is. It, according to the Attorney General in my conversation with her, she says it's a group that protests. Well, I don't think that the court rule 6.106 has any condition that would impose a prior restraint when it comes to bond. It's a
Well, that's not true, because I mean, I heard this argument when I was reviewing the bond condition. Many times bond is about prior restraint, if you're
Yeah,
gonna look
true.
at the definition of prior restraint. So I mean, I don't know that is a compelling argument for the court.
Well, I think the association it's another right that an individual has, a citizen has the right to associate, to organize, and to have meetings with other individuals. This coalition, whatever the coalition stands for, does, or whatever activity they do, I don't think it's necessary as a condition of her bond. I think that it becomes an imposition that is
Not that it matters too much, but I'm calling BS that this attorney is completely ignorant of this organization.
it's a set of standards that doesn't happen in any other case. This is a situation It's not part of her bond condition in the other case that we have pending before this court. I don't have an objection to not going to the University of Michigan except for medical purposes. No problem there.
Let me just ask this. Is she a student at the university?
No, not currently.
Okay.
what the hell are you doing? The Tahrir Coalition is explicitly it's explicitly an organization around the University of Michigan. Allegedly, she was trespass and assaulting a police officer, assault or resisting. I'm not sure which specifically, but they're explicitly a group revolving around the University of Michigan. So what the hell are? Oh my God! They call the United States, North America, Turtle Island. All right, you want to know how unhinged these people are? They refer to North America as Turtle Island. God damn. Dismantle global imperialism, capitalism, white supremacy, and patriarchy. Holy shit. Oh, man. Anyway.
So let me also then I guess ask the question, would there be any reason, so there's no reason that she would need to go to the University of Michigan except if it were
For medical
purposes along those lines, right?
Correct. That's correct.
Okay. I see that her address is a Detroit address. Is that?
That's correct.
That's correct. Okay. So is there any reason that she would need to be in Washtenaw County? And I'll tell you why I'm asking that. It may seem broad, but I also don't believe in placing individuals in positions where they may violate a condition of bond and not now. If it were easy, even for those of us that reside in this county, to figure out exactly where University of Michigan property is, then I wouldn't have a problem. But you could be walking along and all of a sudden she could find herself on U of M property, not necessarily meaning to, but then in at least technical language violating the bond condition. So I try to set parameters that may seem rather restrictive, but also are clear for defendants. And one of the other things certainly let you talk. The other thing is I could not do, for example, I can't say Ann Arbor because University of Michigan properties exist within Washtenaw County, outside of the city of Ann Arbor.
Well, Judge, there's campuses in Flint, there's campuses in Dearborn. There's.
No, I know,
Yeah.
but I'm more worried about here right now. I can't. My wonderful colleagues around the state can worry about those other places. I just have to worry about here. So,
Judge, she has ties to Washtenaw County. If the court's thinking about imposing that, she does have ties to Washtenaw. So I don't know where the court would like to go in terms of imposing a no contact order with the county of Washtenaw. She has ties here. Familial ties, personal ties, friendship ties, work associated ties.
all right, there's going to have to be some information given to the court about this.
Bold of you to assume she has a job.
Is it Tahrir Coalition?
So Your Honor,
don't. Go ahead.
the information that we have in our files is that the Tahrir Coalition is a professional organizing group that advocates for pro-Palestinian policies. And we don't have a problem with the fact that it exists or that it advocates, but Ms. Lewis's involvement with that group has so far resulted in 2 arrests for her that have resulted in charges for resisting and opposing a police officer. And for that reason, we're concerned about the contact that she has with them and the work that she does on their behalf, because it is leading to that kind of assaultive behavior.
Judge, if
But are you are you indicating that her connection to the group, that she somehow is causing others in the group to act in a certain way, or that by her being part of the group, she's now acting in a certain way? I guess I'm
wait,
unclear
sorry.
as to that.
Sure, Your Honor. I don't know if the group is causing her or if she's causing the members of the group to behave the way that they're behaving. But at the last case, the juvenile was arrested for resisting and opposing as well. We elected not to charge her, but there was a juvenile that was involved in this particular protest. She was sort of the ringleader. She was the one that had the loudspeaker. She spoke over the officer who was trying to get the people to disperse and put down signs that they had pointed edges on the sticks. And then she resisted the police officers when they went to arrest her. So our position on it is, I don't know if she's the cause or if she's caused, but either way, she's behaving inappropriately. If she was just speaking, no problem.
Right, but outside of the behavior that different sides may disagree on, I'm trying to figure out if what the correlation is between the behavior that is alleged and her participation or alleged participation with this group or coalition. I'm not.
So I would say that the other prior the other no contact positions I'm not having an issue with. I think I understand why Judge Simpson wants more detail with this one, because it's not as if I mean, I don't know anything about this organization, but I can only assume that it's not as if this organization exists only to protest. I'm sure they have like meetings or some such stuff that would not result in incidents that would lead to an arrest. I think the attorney AG needs to put in a little bit more work, because it's really only speculative that she's like a ringleader. And even if she's a ringleader, I still don't know if we have enough here to warrant her to not have any contact with the organization.
I'm not following it, I guess.
Your Honor, I understand the court's concerns, and in light of the fact that she could do work with the organization, I would rephrase my request to be that she not be involved in any protests with the organization.
Judge, we're not coming to camp.
That's actually, that would be better. I think actually, I think that's a far more allowable. I don't know fully allowable, but I think that draws a better, more. I think that's more. I can't talk today. I think it's better, a little bit better.
Hold on before you go, because I'm sure you've got a lot to say on that.
I do.
Yeah. Well, again, maybe you have to help me here. Is it this To Hear coalition that is responsible for the protest? Is that the piece I'm missing?
That's what we believe to be the case, Your Honor.
Okay. And so, again, so that I'm clear, that the To Hear coalition is alleged, or at least thought to be responsible for the protest. And so you want to restrict this individual's participation with that group because of their responsibility for organizing the protests that have led to this.
That's correct.
Okay. All right. At least understand their position. Maybe I agree, don't agree, but go ahead.
Very well. Thank you, Judge. Respectfully. The defense, and the court is no surprise, the defense is this is free speech, that these are protests, and that this is indicated that she's presumed innocent until proven guilty from the very...
Right. Well, that's exactly what I fully expected the defense counsel to raise that issue as whether or not this would be too far of a violation of her First Amendment right.
Outrageous, ridiculous, and with no merit to the charges that she's brought now twice. Okay, this is going to be very litigated. Her position is that she's not guilty and that she's going to be presumed innocent until proven guilty. The bond conditions, Judge, are supposed to be set so that somebody comes before this court and that there's community safety and other provisions that we've already accomplished one provision of safety for the community. She's not going back to campus. Nothing associated with the University of Michigan. We agree. The further condition of association with Tahrir Coalition, whether or not they're the reason for this group that organizes protest or not, that's, to me, I don't think that they are. I think that the reason why these protests occurred is because the genocide that was happening in Gaza. So
Jesus.
whether it's Tahrir.
Oh, God. Yeah, okay, there it is. Genocide in Gaza.
Your organization, Students for Justice in Palestine, any other of the dozens and dozens of groups that are standing and against.
Yeah, Students for Justice in Palestine, where a whole bunch of chapters were freaking banned and disbanded because they were celebrating Hamas on October 7th. Yeah, but by all means, reference them in a positive light.
Well, the purpose of that protest, they could have been associated with as well, with these protests. You can't just pick one group and say you can't be a part of that because we believe with no evidence. It's just it's a summarily stated
point. Epiphanies, thank you for the 15 months.
Statement by the AG at this point that she can't associate with it. It doesn't have any reason or purpose in a bond condition. It's not necessary. We're not going to campus. We're not going to have any more protests. She's not protesting.
So I think actually I would agree with defense counsel that if she's banned from the University of Michigan, like banned from the campus except for medical reasons. I imagine University of Michigan has a medical center. If she's banned from campus, that might solve it. Assuming that her both of these charges, I think it did say it. Both of these charges involve the University of Michigan. So I think having her banned from campus would cover the concerns that the Attorney General has.
A ceasefire, thankfully, that we've heard of. So I think that the situation has calmed down a bit. However, it's unnecessary at this point, Judge. And 6.106 it's not required. When we get to the other issues of no contact with the co-defendants, Judge, we have joint defense agreements in this case. In the other case, I don't know if we're going to do the same in this case, but the lawyers will be communicating, and there is going to be time when our clients are going to be in rooms with the co-defendants while we're communicating defense in this case. I'm letting the court know that from now. We've been in talks, and we're going to continue to talk to defend our clients. So outside of that, no problem. We're not going to have contact. But I just want to make the court aware that there are joint defenses in this case.
I understand that, and I don't think the court's order would in any way be interpreted to cover the scenario that you're indicating.
Thank you, Judge.
I mean, I don't think it could. So that's the first part of that. The other part, though, is anything else from either side?
Your
Nothing
Honor,
further, Judge.
I didn't hear the last thing that the court said. I'm sorry.
I said, was there anything else from either side?
No, Your Honor.
I will indicate that I'll set the defendant's bond at $10,000 personal recognizance bond. She's not to leave the state of Michigan without permission of the court. She's not to commit any crimes, she is not to commit any crimes. She's immediately notify the court of any change of address. She is not to use any illegal substances. She is not to purchase, possess, or any firearms, ammunition, or anything fashioned to be a weapon. I think that it's too broad regarding the request. Well, there are two real issues here. One being the To Hear Coalition. Without more, this court would have some concern with restricting someone from talking to a particular group. I am not familiar with the To Hear Coalition.
I would agree with that.
But if, for example, that coalition, and again, I don't know, if they have certain different arms of that coalition that do different things, and she might be involved with the humanitarian effort within that, and it would seem improper for the court to stop her from being able to engage in that. So, so without knowing more, I am going to decline to put a prohibition on the defendant that she could not have contact with the To Hear Coalition. By the same token, as I kind of was signaling and would indicate, that except for court-related proceedings and other things, I am going to indicate that the defendant is not to be in Washtenaw County. I don't see a basis or need for her to be here. If she has to visit friends, she has to make certain other arrangements. That will, counsel, you may want to,
And she,
counsel, you may want to mute when you, if she's stuck. I just wanted to,
I'm sorry.
go ahead, you can
Whoops.
finish your question.
Judge, I need to approach, but I don't know how we're going to accomplish that with the AG on Zoom.
Because I'm the master of Zoom, and we will.
Oh boy.
If I may approach, Your Honor.
Pardon? Oh, you need to let go. Oh,
I did. I just like,
Okay.
I need to approach. Just
all right. Here's what we'll do. Ma'am, you can have a seat. Take him yes, and then,
thank you, Judge.
and for the rest of you here, we'll get you home in time for dinner, maybe.
Wherever she
All right. That's right. All right, we're back on the record in the case of the People versus Lewis. Record to reflect we had a bench conference in this case regarding the restrictions. I'm going to indicate that she's not to enter the any University of Michigan property except for medical care.
Thank you very much, Your Honor.
Okay, and so that I can also make the record clear, I am taking no action regarding the To Hear Coalition or any restriction regarding that. If the court, so that everybody, where after exam were to determine some connection where the court would need to place a restriction, then certainly the court may do that. But at this point, I don't see that connection.
Thank you, Judge.
All right. Anything else?
Nothing more for defense. Thank you, Judge.
No,
Thank
Your
you.
Honor, thank you.
Thank you, folks.
So not very spicy, but it also raises a good question as to how far you can go when it comes to prior restraint in as a bond condition. It's just holy shit. This organization, this career organization, they are like batshit extreme. There's no doubt in my mind that the vast majority of the members of this organization probably was cheering on Hamas on October 7th, based on the language that they have on their website. Like they are, it's everything you can think of. I mean, the way they describe their views on the situation, it's obvious that they don't think Israel should exist. Period, which is an insane position to have at this point. But anyway. All right, let's go check out the Eric Martin and see how he failed once again.
This is case 24-2448 SM People versus Eric Martin. And this is a scheduled pretrial conference on the charge of domestic violence.
Good afternoon, Your Honor. Nicholas Darren on behalf of Mr. Martin. who appears to force via Zoom. Mr. Martin, if you could state your name for the record, please.
Capital E, lowercase RIC, of the capital M, lower.
Oh God. Oh God. I don't understand. Why? Bro, look at where you're at right now.
Lowercase ARTIN, family, a private living man, one of the sovereign people.
All right, yeah, this is the pretrial conference. So are you Eric Martin, yes or no?
The living man has been known as by Eric Martin, yes, not the legal fiction corporate entity defendant, though. Spelled in all capital letters name.
Yeah, you're Eric Martin, in other words.
Okay.
The living man has been known as Eric Martin, yes, not a legal fiction corporate entity, though.
Yeah, Mr. Dillon.
Your Honor, I was recently appointed to this case. The prosecutor just sent me the discovery. Mr. Martin has informed me that he filed a couple motions with the court. I haven't had a chance to review them, but in discussing them with them, one of them I'd be comfortable just asking the court. I think I can do it orally even. Mr. Martin has been incarcerated for about 38 days now. And under the applicable court rule on a misdemeanor case, if he's been incarcerated for 28 consecutive days, he can be released on a personal recognizance bond. I think that that's appropriate in this case. The delay in this case was not any fault of his or anything like that. It's just he's unable to post the bond. So I would ask that his bond be changed to a personal recognizance bond from I believe it's $1,000 bond that he has to post. Additionally, I just, like I said, received all the discovery and whatnot. I would need an opportunity to review that. If Mr. Martin would be comfortable wanting to argue his own motions, I have no problem with that. But I have not had a chance to read them, and I would like to know, I wanted to be able to compare them accordingly to the police reports to see what they were. But I do know that just based off of what he's told me, he's been incarcerated for, I believe my count was 38 days. Today will be the 39th day on a 93-day misdemeanor, which would allow for him to be released under the Michigan court rules.
Hello?
Hello?
I heard. No? Hello?
Who are you?
Yeah, do we have the prosecutor available on this matter?
I don't see him.
He was just in here. I did tell him I would be raising this issue.
Okay. Yeah, I'd like to hear from the prosecutor on it.
Okay, Brian, so what I got to say then, before the prosecutor gets a chance to say something?
So, this is on the
Oh my God, there's so much noise.
Charging as a misdemeanor domestic violence, originally
Fletcher Boy, thank you for the $4.99 super chat. Living person bond with a corporate trust bond. I guess we'll find out.
placed on a personal bond. My understanding that he violated bond, and the bond was reset at 2,000 cash because he violated, I think, by having, I think it was, correct me if I'm wrong, contact with the victim.
Judge, Alex Winger for the people, P number PH 6599. So, Judge, it's the people's understanding that the defendant cannot go to that address and went to that address, and he was then taken into custody because of that address that he went to, he's not allowed to go to.
So, and so, Mr. Darren, you want to renew your argument about time period of being in custody on a misdemeanor case and why bond should be personal bond?
Yeah, Your Honor. I'll just briefly, as I did kind of let the prosecutor know, he's been incarcerated for, by my count, 38 days since December 17th when he was picked up. And he's now, it'll be 38 days, 39 after tonight. The court rule states that after 28 days, he can be released on a personal recognizance bond. There are most of the reasons that it would be denied is based on some sort of delay that's attributable to the defense. I know he's had a couple attorneys, but there's always been the court dates have been set. So I think he would be eligible for the release on the personal recognizance bond.
Okay.
Yes,
Oh, no.
I'm saying,
Stop. Oh, God.
Just 1 minute, Mr. Martin. We'll hear from the prosecutor.
Yes, Judge, the people, the victim has been sending conversation talks to the victim advocate, and the people would ask if the defendant is released on a bond that the defendant would have a tether placed on the defendant, therefore that it can be rest assured that the defendant makes no contact with the complaining witness in this matter.
All right.
What's he going to say now?
Yeah, did you want to be heard, Mr. Martin?
yes, okay, now, I want to add, under, not only should, before we get to the bond issue, the case should be dismissed.
Holy shit. This microphone, that's like the worst place for this to happen with the way it's set up. But God, and we just heard him. He wants to dismiss the case. God.
Under, not only should, before we get to the bond issue, the case should be dismissed, which I did file a motion to dismiss already. The court probably just received it because I sent out not too long ago, like last week. Anyways, under MCR 6.004, subsection C 1 through 6 makes it clear that I have a speedy trial right within 28 days. Since I've been in jail illegally over 28 days, this case should be dismissed based on a violation of my speedy trial right. And based on the court rule I just named off, I'll say it again, case everyone heard clearly, MCR 6.004, subsection C 1 through 6, that is the criteria that is to be followed for speedy trial time computations, not the normal excluding Saturdays and Sundays and legal holidays. That's always been followed wrongly, but it's not, like I said, it doesn't apply to speedy trial. So my right to speedy trial has been violated. The case should be dismissed.
Okay.
So I want that decided on first before we address the bond issue. Because as long as that's granted like it should be, then the bond's no issue. But so once the decision's reached on the motion to dismiss, I just filed now. Then once the decision's on that, then I'll address the bond if it's not granted. But that's all I have to say on that for right now.
All right.
Yeah, Mr. Ringo?
Yes, Judge, the defendant doesn't get the benefit of picking new counsel, and then when picking new counsel, reach a date where the case will then be dismissed. There's been, I believe this is the third or fourth defense counsel representing the defendant, and
obviously,
if it would be then in the court's client to dismiss this outright, then defendants would be able to set the ability to just keep picking new defense counsels, and once they get to 28 days, be able to argue that it wasn't a speedy trial and then have the matter dismissed. So it's the people's argument that the case should remain as charged, and addressing bond again, that if the defendant is released on personal bond, but on a tether.
I gotta talk to.
Okay, now, what he just said was, I was gonna say it's irrelevant nonsense. I've been in jail since the 14th of December. That's a fact, cannot be disputed. I've been in jail since the 14th of December is when I was arrested by Taylor cops illegally, based on no evidence, based on my brother's lying allegation that I sold him, which is all it is, it's a lying allegation. But anyways, the fact is I've been in jail on the 14th till now. It's over 28 days. The court rule again, MCR 6.004, subsection C 1 through 6 makes it clear when you are in jail consistently for 28 days, your right to speedy trial has been violated. It demands the case, calls for the case to be dismissed. Simple as that. Everything else
Simple as.
saying is nonsense.
I'm in this video and I don't understand how I got put here.
Random ass dude just decides to pipe up.
All right, we're gonna put you on mute, Mr. Kerr. This isn't your case at this
I'm
time.
supposed to be the defendant or the plaintiff or whatever. Hello?
All right.
Nobody even talked to me. Hello?
All right,
Hello?
so thank you. Yeah, who's speaking now?
This is Kurt Martin, the brother,
All right.
Is this dude medicated?
Did you want to comment on this whole matter at this time, Mr. Martin?
no, I mean, no. I couldn't even I didn't even know that it was today, the court. Thought that it was yesterday, and I was just called by the prosecutor that it's going on today. I've been hospitalized, and I'm now in a facility that's taking care of me, and
Okay.
so that's
Okay.
I don't have nothing really to comment about. I mean,
Thank you for that invaluable contribution to the hearing.
I just want to make sure that you can see me and I was heard, because there's nobody that see me or something.
All right, well, thank you, Mr. Kurt Martin. So, all right, I'm denying the defendant's motion to dismiss based upon his changing of defense attorneys. The delays appear to be to a great measure caused by him by violating his bond conditions and repeatedly changing attorneys. That motion is denied.
Well,
I will allow a personal bond in the case of $2,500 conditional upon a GPS tether and preventing the defendant from going within 1 mile of the victim's residence or having any contact with the.
Oh God, don't tell me he's just going to basically say, like, you can't tell me what to do or tell me where I can't go. And that's going to blow up his bond hearing.
The victim, as well as no alcohol or illegal controlled substances, coming to court when required, advising the court of changes of address or telephone number, and not leaving the state without the consent of the court, not to possess any weapons and or firearms. And we'll give you another date for court. That'll be, we're going to need an address for you or phone number, Mr. Eric Martin, for that hearing. Or you can come to the court and get that date. Come to the court and get that date, Mr. Eric.
I have objections to, can I talk now? I have objections to your order now.
Okay.
Can I make objections now to your order?
I did not hear that.
I said I have objections to your order. Now, first of all, the in objection to your order, no delay is being attributed to me switching attorneys. That's false. Okay, I have not intention.
Oh my God, he's relitigating that. Oh God, dude, it's over. He made the decision.
Said, give me this attorney over that attorney. Whatever they did, that's what they did. You know what I mean? I told Slavin from the jump, yes, I want an attorney. Nothing is attributable to me. So the motion should have been granted, number one. Number two, even if you still don't grant the motion to dismiss like you're supposed to, I object to the bond condition. They violate my due process rights. I don't lose my due process right to be at my house. I've been living there for 32 years. Yeah. The house I've been living there for 32.
Oh my God.
2 years, regardless whether it's mine or not, okay?
Do you understand? I understand your position, Mr. Martin. Are you telling me that you're unable to abide by my bond conditions?
That's right, because I have no other house to go to.
All right, Mr. Martin.
I have no other house to go to. And it violates my due process anyways.
Yes, so Mr. Martin is telling me preemptively he will not abide by those bond conditions. Therefore, I am going to change the bond back to the original bond and keep it at the cash bond because he poses a serious threat to the community. He's already demonstrated he will not comply with the bond conditions. And now he's preemptively telling me that he will not comply with the bond conditions I've just set. So therefore, your bond is remaining at what it was before, the cash bond. We will reset the pretrial conference and a notice will be sent out for that next pretrial conference. Same bond conditions. And
That violates my due process. I want to appeal this now. I want to appeal this to the Court of Appeals ASAP. It don't violate my due process. It violates my.
I love how his defense attorney was the first one to go.
All right.
And he's muted.
Thank you. That's going to end the hearing.
We'll get the court date in the mail, Judge.
Oh, there it is.
Yes, sir.
Oh, he's back.
All right. Thank you very much.
Thank you.
All right, what now?
Judge, is anybody there?
Oh my God. All right. What an idiot. Yeah. And that's how you know that somebody is in way too deep. Ugh. Sorry. Moron. All right. I think we're gonna call it there today. I want to thank you guys for being here to watch the shenanigans. At least we ended on an entertaining note rather than dealing with the foreign policy and international politics that sometimes happens over here. All right, you guys take care. Have a good one. I'll see you guys either tomorrow or Friday. But yep, check me out. Hit that like button on your way out. It really helps the channel. And check me out on Discord. All right, have a good night. See ya.